Swayam Prabha. Digital India. Educated India.
Welcome to the third lecture of the subject Business Law, and the topic for today is Introduction to Contract and Essentials of a Valid Contract Part 3. I am Dr. Rama Bansal, working as Assistant Professor at Arya College, Ludhiana. This project is sponsored by DTH Swayam Prabha, MHRD, New Delhi. In this lecture, we are going to cover the remaining essentials of a valid contract. We have till now discussed 5 different essentials in previous lectures. Now, in this lecture, we would be covering the rest of 5, that is lawful object, certainty of meaning, possibility of performance, not declared to be void or illegal, and at last the legal formalities. This is the 6th point for the essentials of a valid contract, that is lawful object. First of all, what is the lawful object? Section 23 of Indian Contract Act 1872 says that all agreements are contracts if they are made for lawful consideration and with lawful object, and every agreement of which the object or consideration is unlawful is void. Means for any contract where the object is not lawful, object of contract is not lawful, that contract is void contract. Here the void we have already discussed, that is which is not enforceable at law. With all the essentials of a valid contract, the important part regarding the object is discussed here. When the object is lawful, the contract can be enforced at law, but when the object of the contract is unlawful, the agreement is totally void. Let's take an example. A debtor, finding himself in position of insolvency, agrees to pay his creditor B in full as against the other creditors. The agreement between A and B is void, though the consideration, that is a payment of debt, is lawful, but the object here is totally unlawful. The consideration or object of an agreement is lawful. Otherwise, it's lawful, but in few cases, the court says that the object of an agreement or consideration of an agreement is unlawful. So, what are those cases? First is if it is forbidden by law. If any consideration or object, if it is forbidden by law, if the law says this is not right, then this object or consideration is unlawful. When it is prohibited by special legislations or regulations. Let's take an example. An agreement to pay consideration to a tenant to induce him to vacate government premises governed by the Rent Restrictions Act is illegal and cannot be enforced. Reason being, this type of act is totally prohibited by the special legislation or the regulation. Here in this example, the Rent Restrictions Act prohibit this type of activity. So where the object or the consideration is forbidden by any Indian law under the Indian Contract Act 1872, this is totally unlawful. To prove this point, one more example can be discussed. As if X pays to Y that I will pay you rupees 10,000 if you assault your friend that the name is Z. So in this case, to assault Z, A is paying rupees 10,000 to B. So such type of acts are forbidden by law. Law does not permit for such kind of acts. In a similar example, like if a person whose business is selling of liquor transfers his whole business to the another person who don't have the valid license for that, If such kind of activity is done, that means the other person who don't have the license to sell the liquor, and this person is selling him the license for certain sum of money, that means this is again forbidden by law. Law does not permit to do that. Again, if A contracts with B to smuggle some goods to the another country, and this type of contract where the smuggling is involved, where the goods are to be smuggled, this type of contracts are also forbidden by law. They are against the special legislation and the regulations. So in short, we can say the acts which are forbidden by law, which are specially restricted by legislations or regulations, involves the unlawful consideration or unlawful object, are considered to be the invalid contracts. Next point is, it would defeat the provisions of any law. If the object or consideration is defeating the provisions of any law, this is unlawful object or unlawful consideration. Let's see the example. An agreement between husband and wife to live separately is invalid as being opposed to Hindu law. To prove this point, one example may be quoted, like if A borrowed rupees 5 lakh from B and agreed not to raise any objection as the limitation, and B may recover the amount even after the expiry of the limitation of period. So this agreement is void as it would defeat the provisions of law of limitation act. Similarly, if two parties or if more than two persons have agreed to carry on business in partnership, and they have signed an agreement in which they have provided that they would conceal some part of their business information and would not enter certain items in the books of accounts with a view to evade the payment of income tax as well as the sale tax. If the one of the partners brought an action against others for accounts and for also the recovery of the amount which was due to him, so in this example his action may be dismissed as the agreement was aimed at defeating the provisions of Income Tax Act and it was opposed to public policy, and therefore same may not be enforceable. So it is always required that the contract entered should be according to the provisions of any law. That means if any consideration is forbidden by law or any object is forbidden by law under special legislation or regulation or under the provisions of any law, this is unlawful object or unlawful consideration. Let's take one more example. If say any Hindu husband whose legal wife is alive and he agrees to marry the another wife, so here to marry a woman is a valid contract, but according to Hindu law, when a wife is alive, a legal wife is alive, Hindu husband can't marry to another woman, so the object here is unlawful. So these type of contracts are not valid contracts. Second is, if it is fraudulent. The Indian Contract Act 1872 says that any object which is fraudulent can't give rise to the enforceability of the contract. Let's see the example. A, B and C enter into an agreement for the division among them of gains acquired by them by fraud. Means they are entering into an agreement in which they are talking about sharing the gains acquired by some fraud activity. So this type of agreement is void and its because as its object is unlawful. The same thing can be identified from the case of Mani Ram versus Purushottam Lal. What happened in this case? Mr. A always knows that the railway company is not going to the contract to Mr. A. So what Mr. A did, he entered into a contract with Mr. B separately so that Mr. B should forward his application to the railway department for the real contractor. And what are the facts of the case here? That Mr. A always knows that the railway company is not going to give him the contract for the real contractor. So what Mr. A did, Mr. A entered into a contract with Mr. B separately that Mr. B should forward Mr. A's application to the railway department so that he can act as a real contractor. Here it is pre-known that the objective of the A was to cheat, to fraud to fraud the railway company. So the objective of committing the fraud is always unlawful. That means in this case the court held that the agreement made between A and B was always a void agreement. Next, fourth point is it involves or implies injuries to the person or property of another. If any contract or any agreement involves the injury to the person or the property of another, this type of agreement can never be said that it is a valid contract. So here injury means doing something criminally or doing some wrongful harm to a person. This is being cleared from the case of W. H. Smith and Sons versus Clinton. The facts of the case are A promised to B to pay rupees 500. B is a editor of the newspaper. A told him to publish his defensory article against C, so with which C's reputation may be harmed. So this type of contract is always a void agreement, because here the intention is to give injury to the image of the person or to the property of the another person. So in both these cases the object of the contract is unlawful, so the agreement is void. Next point is agreements for which object or consideration is unlawful in part. If we say the whole object or the whole consideration was not unlawful, a part of that was lawful and part of that was unlawful, so what is to be done there? So in that case it is being mentioned, if these two things can be separated, if these two things can be separated, only then the lawful part may be enforceable and unlawful would be a void. But if these two things cannot be separated, then the whole agreement would be unlawful. A whole agreement would be unenforceable. Let's take an example. A promises to work for B, a legal manufacturer of indigo, and illegal traffic in other articles. Here there are two things involved. One portion is dealing with the lawful part and another part is dealing with the unlawful things. B promises to pay a salary of rupees 10,000 per annum. So now the services of B are for the legal as well as for the illegal part. So the court says that the agreement is void because the services of B cannot be separated for the legal and illegal part. The last point under this is the court regards it as opposed to public policy. If the court has regarded a few activities as opposed to public policy, in that case this contract is not enforceable. So what are the acts which are opposed to public policy? Which tends to promote corruption or injustice or is against the interest of the public. For example, contract of smuggling, etc. So the activities which are being defined as opposed to public policy by the court, they are unenforceable. Now we will read what are the acts which are being considered opposed to public policy by the court. The first one is trading with enemy. If any person, any party is trading with enemy means enemy country. So if one person is trading with his enemy country, this is against the public policy. Let's take an example. When the contract was made, it was totally a peace time. Two persons, person A and person B has made a contract, and there was a peaceful situation between two companies, but yet the performance is to be done before that the war breakdown. In that case, now the both parties have two options. One option is either they should suspend their performance, or second is they should dissolve the contract. That means any activity, any contract, any trading with the enemy country is counted as opposed to public policy. Next is stifling prosecutions. We all know, we always say that the criminals must be punished and prosecuted. Any agreement to stifle a prosecution is always considered as opposed to public policy. An agreement to stifle a prosecution already instituted is illegal and void. That means if there is any agreement which is where the prosecution is already instituted and the agreement is to stifle a prosecution, that type of agreement is illegal and void. I can give you one example, like A told B to withdraw a criminal case already instituted against him, and if he do so, he will pay him a certain sum of money. And this type of agreement is illegal and void, as the prosecution is already instituted in the court. And the agreement made before any complaint, if it is filed, it would not amount to stifling of prosecution. If the case is already not instituted and still the complaint is not filed, and before that if any agreement is made, it would be legal and it would not be counted as a stifling of prosecution. Third is withdrawal of prosecution with good motive is also not counted as stifling. We come to the third point, that is maintenance and temporality. What is the meaning of maintenance first? Maintenance is a person's promise to maintain a suit in which he has no interest. And temporality is when a person agrees to assist another in litigation in exchange of a promise to hand over a portion of the proceeds of the action. In India, both these acts are permissible, but if we talk about the English law, both are counted as illegal and unenforceable. Means any activity which leads to maintenance and temporality would be counted as opposed to public policy in English law, but in India it is being considered as lawful up to some extent. In India it's valid. Let's take an example. If a CA files a return on the behalf of his client and he saves the tax by remaining in the limits of the Income Tax Act 1961, and if he saves a major portion of the client and there is an agreement that he would take a part of that, he would take a portion of the proceeds of the action, then this is valid. So in India, maintenance and temporality are valid unless it is unreasonable so as to be unjust to other party, or it is made by malicious motive like gambling. Next point is traffic relating to public offices. Any activity, any agreement relating to traffic to public offices is counted as opposed to public policy. Let's take an example. A paid B, a public servant, a certain sum of money in inducing him to retire from service, because the person is having a lot of time to get retired, but A himself wants to be at his place, so he is offering some money, he is inducing the person B to retire from service, thus paving the way for A to be appointed at his place. So this type of agreement is counted as a void agreement. Next is agreement standing to create interest opposed to duty. Any agreement which tends to create interest opposed to duty is counted as against the public policy. Let's see the example. A agrees to pay B, the lieutenant colonel in the army, rupees 50,000 if he will assist her brother to desert the army. So this agreement is void and illegal as it is deterring the army man from doing his own duty. Next point is marriage brokerage agreements. If any agreement which is counted as marriage brokerage agreement is done, this is counted as opposed to public policy, and this can be well understood with the case of the Amir Chand versus Ram Ratan Chand. The facts of the case are Mr. A proposed the marriage of his widow niece with B, and he promised that he will pay gold, jewelry and land and all other properties, and the marriage was executed, and later on after marriage he just denied to pay rest of the amounts, that he is not going to pay anything now. So in this case, if any suit is being made, that suit is not acceptable. Reason being, this is a void agreement because these type of agreements are against the public policy. Next is agreement standing to create monopolies. If any such agreement is being made, let's take an example. If A says to B and C that I will give you rupees this much, you would not sell your product in my area. That means in that area, if B and C do not sell the product, then A can sell the product at his own prices. So that means this type of agreements creates the monopolies, and these are not in the public interest. Next point is agreements to influence election to public offices. Means if any agreement is done with the voters or the rivals, that means these type of agreements are giving rise to the corruption that is against the public policy. Next is agreements in restraint of personal liability. If there is any agreement which is restraining the personal liberty of any person, let's take an example. A and B are making the promise that A will pay a certain sum of money to B, and in lieu of that, B has to take permission of A for everything, for any agreement, for going somewhere, for signing a check and all that. That means this type of agreement is taking the personal liberty of B, and the agreements in restraint of personal liberty are counted as opposed to public policy. Next is agreements interfering with marital duties. If any agreement is interfering with marital duties of married couple, that means that is against the public policy. Let's take an example. An agreement to lend money to a woman in consideration of her getting a divorce and marrying the lender is void, because in this case this agreement is interfering with the marital duties of a woman to be honest with his husband. So till now we have discussed with the lawful object that there must be lawful object in the contract to make it a valid contract. Now we move to the next point, that is a certainty of meaning. Section 29 of Indian Contract Act defines that agreements the meaning of which is not certain or capable of being made certain are void. Here certainty means it should be the clear thing. Like if I say certain sum of money may be having different meaning for me and different meaning for you. If I say we will go someplace after a few days may be 2 days for you and 5 days for me, that means the meaning is not clear. So the terms of the contract must be precise and certain. That means if I say कि I will go there on Monday, the other person should also take it Monday. If I say I will pay you rupees 10,000, the other person should also take it rupees 10,000. It should not be vague. A contract may be void on the ground of uncertainty. If any such contract is being made which is not possible to perform, which is totally uncertain, so that may be counted as the void contract. Let's take an example. A agreed to sell to B 100 tons of oil. Here it is not being made clear that what kind of oil is intended to be sold. So in this case, the agreement is not valid as the terms of the contract are not certain. Next point is possibility of performance. Section 37 of Indian Contract Act lays down that the parties to a contract must either perform or offer to perform their respective performances unless such performance is dispensed with or excused. If the act is impossible in itself, means impossible to perform physically or legally, and it can never be enforced at law. Let's take an example. If Mr. A contracts with Mrs. A that he would have the stars from the sky for her if she transfers rupees 1 lakh into his name. So in this case, to get the stars from the sky is not a possible thing. It is totally impossible. And similarly, it can be seen in the example, Mr. A agrees with B to discover treasure by magic. Such task is not possible to perform, so such agreement is never enforceable. That means to make a contract enforceable with the other valid essentials, the possibility of performance is also required. Next is not declared to be void or illegal. Agreements mentioned in section 24 to 30 and 56 of Indian Contract Act 1872, which we will read in further presentations, have been expressly declared to be void. So the agreement satisfying all the conditions of a valid contract must not have been declared void by any law in force in the courts. For example, any agreement in restraint of marriage, in restraint of trade, or legal proceedings is said to be void. Next is a legal formalities. So the last essential of a valid contract is a legal formalities. A contract may be written or oral, as we have read, except in cases where registration is required. So all the formalities, especially in case of mortgages, in case of sale or purchase or lease or gifting of immovable property or negotiable instruments or memorandum and articles of association, where the legal formalities are required, that must be completed. If in any case any legal formality is left, that contract is not enforceable at law. Let's take an example. If in case of sale of immovable property, some stamp is required. So if the stamp is missing and all the 9 essential factors are present into a contract, but in the absence of that stamp, this contract cannot be enforced. That means this is not a valid contract. So by now we have discussed the 10 points that are essential for a valid contract. So in the summary, I would summarize the whole 10 points which we have discussed by now to make a contract a valid contract. So a valid contract is that contract which includes all the valid points, all the valid things which are essential under section 10 of Indian Contract Act 1872. So among the all 10 points, the first point was offer and acceptance. There should be valid offer and there should be valid acceptance. Second, we have discussed there should be an intention to create a legal relationship, in which we can quote the case of welfare versus welfare. Then in the next point we have discussed there should be a valid consideration, and we have also discussed the points with reference to stranger to consideration and stranger to contract, and no consideration, no contract exceptions. Then next we have discussed the capacity of the parties, that there are minor and persons of unsound mind and the persons disqualified by law who are not not capable of entering into a contract. Then at the fifth point we have discussed the free consent. The consent is not said to be the free when it is affected by coercion, undue influence, fraud, misrepresentation, or the mistake. And in this lecture we have covered the rest of the 5 points. That was lawful object must be there, the certainty of the meaning of the terms in the contract is required, the possibility of performance should be there, the agreement should not be void or illegal, and there must be some legal formalities which are to be fulfilled. So here we have completed with all the essentials of a valid contract. Thank you so much.